There it is. Great. Oh, it's on the other side today. Welcome, everybody. It's Tuesday, April 8th. Wow, time's flying by. We're here in Senate Economic Development, Housing and General Affairs, and we are beginning to go into depth on the House Bill H-479, which is their housing bill. They're going into depth on our housing bill, S-127. And we will merge them at some point, but right now we're continuing to do our separate work and looking at each other's proposals. And today we are delighted to welcome our own legislative counsel, Ellen Czajkowski, back into this committee to address sections 8 through 12 on municipal appeals. And so we have both the side-by-side in front of us and the full bill for us to look at, and we welcome you, Ellen. And I think you've met us all except maybe David.
Just introduce.
Oh, great. Okay, perfect. Great, perfect. So, Ellen, it's yours. And Keisha is presenting in the House Ag.
Kathy's just joined us.
And Kathy Byer is joining us too. And Kathy's going to join in after you walk through the bill and after we have some initial conversation.
Ellen Czajkowski, Office of Legislative Counsel. So H-479 as passed by the House. There are a handful of sections related to municipal appeals and housing. And so the sections that I drafted start at the bottom of page 17, section 8. And they are labeled housing appeals. And so the reading it through, it is a standard walkthrough I will do, but it is not the most intuitive because this is an overhaul of who is allowed to appeal municipal permit decisions, and it uses 3 different sections of the bill in cooperation to accomplish that. So if at any point you're a bit confused, I will slow down and explain it, but it's going to use multiple sections to do the same, to accomplish the same goal. So section 8 is amending the definition section of the court statutes, the environmental court statutes. So that's in 10 VSA 8502. And these are the definitions that apply to environmental appeal. So at the top of page 18, the definition of person aggrieved is being amended to include appropriate municipal panels decisions. And so those are the decisions that municipalities make on their zoning permits. So person aggrieved is a person who alleges an injury to a particularized interest protected by the provisions of 8503. So there's a list of statutes in 8503. Those are the statutes that the environmental court has jurisdiction over. And so currently it's acts by the district coordinator, the district commission, and those are both Acts 250 decisions,
right,
and the secretary of ANR. So this definition of person aggrieved, so who can appeal, currently this is the same definition that's used in both Act 250 and ANR permits, but this is extending it to the decisions by an appropriate municipal panel, so municipal zoning permit decisions. It's also using this phrase particularized interest that previously wasn't part of the determination for zoning permits. And so that does require that there be the risk of specific injury to the person aggrieved who's seeking to appeal. This is more specific than what's currently required for municipal appeals.
And where is that risk that's coming up? Where is that language? Because it's not.
So
alleges an injury.
So on the top of page 18, we're talking here about an injury to a particularized interest protected by the chapter. What's currently in statute for the municipalities is coming up in section 10. I'm going to get to it. So that's why I'm saying it's multiple sections are working in concert here to change this. But yes, person aggrieved is what we're moving towards here. Section 9 is still in the chapter related to environmental appeals. And so this is doing a couple of things. So first, it's adding that reference to the person agreed that I just described. So within 30 days of an act or decision, an interested person, which is a current requirement in the municipal permit statute, or a person aggrieved who has participated as defined by 4471 in the municipal regulatory proceeding under the chapter may appeal to the environmental division and after decision made by that chapter. So, go ahead.
No.
So this is the standard for who can appeal to the environmental division a decision of planning and zoning. Currently, it is interested persons who have participated in the public hearings on the issue. And now it's adding, or a person aggrieved who has participated in the hearing on the issue.
So my question is, interested person. That's a pretty broad definition. And so maybe you'd like to touch on that with them.
Yeah. Would it be helpful if I talked about that?
Whenever you think it's appropriate.
Maybe we should jump to that. So that's section 10. So let's jump to section 10. So currently.
So we don't get rid of interested person here. We just
We're narrowing.
add, we're narrowing.
Yes. So in section 10, the current statute 4465 sets out who can appeal municipal permits. And it currently has 5 types of people listed as who are the interested persons who can appeal. And as part of this amendment, you're getting rid of 2 of them and sort of merging that into the aggrieved persons. So it's leaving the other type of persons as those who are interested. So those people who are left. So this is language that's on page 21 if you're looking at the bill. It's the person owning title to property or municipality or solid with, yep.
And just, if you're looking at the side by side, it is on page, because I've been sort of following along with both. Yeah.
Yeah, but I don't think there's anything in your bill that would put it like next to a side by side.
There isn't, that's okay, we still
Okay.
have it.
Oh,
So it begins on page 16 with section 8. And now I have, anyway, it's page 18 of our side by side.
so interested persons that are not changing. It's person owning the property, a municipality or solid waste management district empowered to condemn, who are going to be affected by the bylaw or change. It's also the municipality at issue or the adjoining municipality. And then any department or administrative subdivision of the state owning property within the municipality. So we are leaving as interested persons the person who actually owns the property, solid waste districts, the municipality at issue, and adjoining municipalities, and then state agencies that may have an interest. And so it's not requiring that they demonstrate an injury, but they have to, they're interested by definition, and they also have to participate in a hearing, and then they are eligible to appeal.
But they are not abutters, so they are not immediately affected by being next to anything. They are interested by these definitions on.
By these definitions, yes. And so the definitions that are being struck and then being sort of captured in the definition of aggrieved person are what was number 3, which was a person owning property or occupying property in the immediate neighborhood of the property at issue who can demonstrate physical or environmental impact. And then the any 20 persons group standing. And so last year you changed it to 20 people, but prior to that, it was any 10 people who were a combination of voters, residents, or real property owners within the municipality. They could be considered an interested person. And so there have been different proposals about the size of the group that should be allowed to have this interested person standing. But House General just decided to strike the whole concept, as well as the person in the immediate neighborhood of, and merge it into this concept of aggrieved person. And so now it's any person who could be residing anywhere who can demonstrate that they have a particularized interest, that a risk of injury caused by this potential project can now appeal.
And that's I would assume a fairly high bar. I mean, you have to show.
So it's a higher bar than what's currently required,
Right.
because there wasn't that demonstration required previously. However, this is the standard that's currently used in both the Act 250 cases and the ANR appeals. And it's actually akin to what broadly in other cases is required for standing. There has to be, a person has to be potentially injured by the decision.
Particularized means it has to be specific to them. It can't be just traffic at large. It has to be that there will be trucks that will continually pass right by my driveway, which means I need to reinforce the bank. So that's particularized.
Yes, and it's
Air pollution, that would not be particularized.
yes, it's hard to give examples because of how specific it can be, but yes, the distinction is not by the general public. Apart from the general interest of others or the general public. So not a general concern that could be shared by the general public, something specific to that person and or their use and enjoyment of their property or the property at issue. So there are lots of examples in case law from both ANR and Act 250 permits where this has come up. But it is pretty fact dependent on what's going on, and someone has to be able to show their individual use or risk of impact separate from general public interest.
So if I use an
Yeah.
example, I'm producing some sort of a waste disposal or heating mechanism that produces smoke. And the prevailing winds are such that this heavy black smoke, even though I'm the second property owner over, goes into my yard and prevents me from using my outdoor facilities. How would that figure into a particular use?
That could the court could find if you had evidence that it was not just the whole town having impact from smoke, but that something specific to your use would be impacted differently than the general public. The court would evaluate the type of evidence you had on that. And also most of these decisions are happening before the project has started. And so it is speculative. It's often, but it is asking the person bringing the appeal, what is your evidence that you do think you're going to be impacted based on what the project, how it's being described now.
So that's the fact dependency.
Yeah.
So it would have to have the same kind of condition would have to occur elsewhere and have produced a result that could be related to.
No, but Mentor, based on the information that you've seen from the applicant, what is it that you think could be happening?
Well, I guess you
Yeah.
could say something to the
Yeah.
effect that we know that the prevailing wind is thus.
Yes.
We know that this particular device produces black smoke. We know that smoke floats on the wind.
Yeah.
And then the court decides, well, you don't have enough of an interest, and so we deny your appeal. The person goes ahead and builds it, and the black smoke comes and does exactly what the guy says. At that point, there's no recourse.
Well, at that point, we would want to make sure that they are in compliance with any, that you can see that issue like ANR does have, air pollution standards and permits requiring. So you have to make sure that they are actually complying with other required permits. And then if you have, you could potentially be able to have a nuisance or a trespass lawsuit. Because if someone is interfering with your use of enjoyment after a project has been built to the specifications, they still could be interfering with your use of the property. And so you would have a different mechanism. But there are lots of examples in existing systems like Act 250 where people have been able to get status to appeal. And that is also why, though, you're required to participate at the public hearing stage so that you can bring you can raise your issue early in the process to make sure it is addressed. And then if it isn't addressed, you have the option to appeal.
But this is all before construction starts. This is at the municipal level, which means, and does this then once we finish all these sections, once the appeals are exhausted at the municipal level, it means the appeals are done, right? Is that part of the hope here?
No.
No, okay, that's all
Well,
generally.
so this is not changing the appeal route at all. It is still municipal permit stage. Then they have the option of the environmental division, and then you have the option of the Supreme Court. It's not changing any of that.
Right.
When Representative Hawley was, first of all, I want to say I support this, it makes a lot of sense, so I'm
Yeah.
not criticizing this in any way. But when Rep. Mulhauly was presenting this, he said something that I wanted to tease apart, but we're running out of time. That right now, if a person is aggrieved by an action on another person, they have recourse just based on our constitutional laws. But I don't know if that's necessarily true, but does this just make it clearly germane to a specific path that you were just describing, that this makes them relevant for the municipal level and then the environmental district? So this just gives a route for appellants to go through a more structured process. But in general, anybody can sue somebody else if they're feeling aggrieved and can prove that in a court of law. Is that fair to say? Am I making any
Yes.
sense? Okay.
Yes. So there's a couple things. So yes, if you are injured by something, you may have the ability to sue regardless. However, in these land use cases, there are specifically defined classes of who can appeal. And currently under the municipal standing requirement, there isn't an injury required.
Right, and so
I
that's what,
guess
that is the big
Yeah.
plus of this particular lead
Yes.
section, is that we're adding, you have to show that you have have a particularized interest and that you have been injured.
It will be-
More consistent with general law.
Yes.
Okay.
Yep.
David? Okay. Me too.
All right, so back to section 9. So there's on page 19 in subdivision H, there is a slightly different topic. So still in the statutes regarding the environmental division. Language is being added to the environmental division's standard of review. So standing, and what we have been talking about is standing and who gets to appeal. There's this concept of standard of review, which is how the appeal is taken. And House General and Housing added this language on page 19, attempting to sort of clarify the standard of review for housing permits. So for a municipal land use permit application for a housing development, if the appeal is of a denial, the environmental division shall determine if the application is consistent with the municipal bylaw or land use regulation that directly affects the property, or if the appeal is of an approval, if the application is inconsistent with the bylaw that directly affects the property. So this language is not changing what is currently done at the court. It's not doing much. It's stating what already happens at the.
But calling it out or clarifying it, I mean, there's
I
a
don't
reason
think
they chose to add it here.
I don't think it's clarifying it. I think it is just putting it here as a statement. That this is how they would like the review to work. But I don't think it's changing what the court is already doing.
But is it changing how it's doing it?
No.
So is it reinforcing? What's the right active verb for what it does? Perhaps.
Sure.
Okay,
I don't think it is adding much or changing much.
but it's there for a reason, so we'll ask Mark when he comes in to clarify.
The other thing that's being added in section 9 on page 20 is a statement about prioritizing housing appeals. So except for cases the court considers it.
5,
Yes. Yep. So except for cases the court considers of greater importance, appeals of appropriate municipal panel decision under 24 VSA chapter 117, the zoning chapter involving housing development, takes precedence on the docket over other cases and shall be assigned for hearing and trial or for argument accordingly. So this is asking the court to prioritize municipal housing permits. There is you know, separation of powers comes to mind when you try to dictate how the court orders their dockets. Provision though currently exists like this for open meeting law provisions, and it is pretty vague. It does give the court the ability to decide what cases are of greater importance, and also just ask them to set it accordingly. So it's not requiring any specific deadline. And so the court, I believe, testified that they don't see this as an issue or an imposition on their authority to set their docket, but just asking them to prioritize housing.
So we just did this in another section with A&R, where we have asked them to prioritize housing developments in the housing work in the brownfield sector.
Mhm.
So that we didn't discuss the separation of powers in that situation, although we do it all the time with the administration. We
Yes, because
require things of them.
it's different.
Why?
So the interaction between the legislative branch setting a program and a policy decision that the executive branch then gets to execute, they're always executing your policy.
Right.
This is about the court setting its own schedule and how it operates within itself.
But they're okay with it.
Yes. But setting specific deadlines on how quickly they have to act would be perhaps encroaching on
A
that.
step too far.
Yeah.
Which did a certain amount of pushback last year when we
Yeah.
did this with Judge Sone was in and pushed back quite a bit when we were trying to set
Yeah.
actual timelines
Yeah.
for decisions. Yes.
All right. And so section 10, I already talked about. It's changing the definition of interested person so that those other two definitions are basically captured as part of the aggrieved person determination.
And the agreed person.
Yeah.
Section 8. Okay.
Yes. So then section 11 is a different topic, but still in municipal zoning. So this is amending 4441. And this is about bylaw amendments. So notwithstanding this section and any other law to the contrary, for bylaw amendments that are required to comply with amendments to this chapter, no hearings are required to be held on the bylaw amendments. So we're talking about the municipal zoning chapter and you all making amendments to that chapter. And so when you make an amendment to the zoning chapter, it controls what municipalities have done with their zoning, but it usually does require them to update their zoning to match what you've done. This is saying when an amendment is made, no hearing is required to be held on the bylaw amendments that are required because of that amendment.
So it reduces their workload, presumably a lot.
Yeah. I do want to flag something for the people who are listening. I am wondering if, so as I've talked about, the ability to appeal, you have to be either an interested person or an aggrieved person. And both of those people have to have participated either orally or via written communication at the hearing on the issue. So that also applies to bylaws. And you're getting rid of the hearing on the bylaws.
I see where you're going with
So
it.
you
It
want to
reduces.
flag. I do think perhaps if there was no hearing actually held on an issue, a person could raise that they could not have participated and therefore manifest injustice would be an issue if they couldn't then appeal. So I do think perhaps the court would address that, but I don't think that came up in any testimony because this provision, section 11, was sort of talked about independent of the appeal, but I do just want to raise that I could potentially foresee an issue if there is no hearing held that you're required participation in a hearing in order to appeal.
But there are numbers of other hearings for them to participate. Yeah.
If this is saying that, so we're talking specifically now not about permits, talking about just general, people have the ability to appeal a bylaw if they are if they don't like it, if they don't like how their property has been zoned, or the application of the zoning bylaw to their own property, regardless of them trying to build something, they have the ability under the statute currently to appeal that decision on the zoning itself. And so here, if there's no hearing held, I think it could risk their ability to appeal that decision.
So I mean, the overall intent here was that they have to participate in some way. It doesn't, I mean, the hearing was a good proxy in the past, but you're saying if we want to legislate that they have to participate in some way in good faith before they appeal, do you have suggestions about how we might word that without participation in a hearing?
No. No.
Okay. Well, if someone else does, let us
Yes.
know.
That's what, I know there are people listening.
Yes.
This
I just want to underscore our intent.
Yeah.
And
Right,
if
no,
people agree, because
Right.
I get asked all the time when we leave, what was our intent? You will too. So if people agree with that intent, that we don't want someone to bring their unique concern up well outside of the time period when there's the opportunity to engage in good faith, then we just need to rewrite the section if that's our intent.
But there are, in terms of engagement and hearings, there are many other opportunities, one assumes, although maybe not in this particularized case with the bylaws.
Yeah, this is a pretty narrow.
This is very narrow.
Yeah, and it's based on, some of the examples from the last few years.
Yeah,
Some of
give
it-
us a good example. That would be helpful.
Sure. So, in the last couple of years, you've made changes to a town's ability to require a set number of parking spaces per project,
Right.
per development, and that was pretty uniform across the state of it's 1.5, and so there really isn't much area in that to make different. There's not a lot of wiggle room of what could be the gray areas in that proposal. But there was some language. See, I probably should have read this before I started talking. About proximity to other parking. And so if there's a question about how close they are to other available parking, people may want to weigh in. But some of the other, the distinguishing where the zones are, in other cases you've required, if it's in an area along water and sewer. There's much more gray area on that requirement. And so I think that this language is pretty broad, but it encompasses a lot of different types of amendments you could all be requiring. And there may be, yes, this is encompassing a lot. So you may want to hear if there's any risks here.
Did House General hear from VLCT or from the planners or, people who were participating in these bylaw hearings after we passed these changes, how much time they're consuming? I mean, is this a huge time consumer?
Yes.
What problem are we solving is, I guess, my question.
Yeah, VLCT spoke about this, but yeah.
For my city council days, every time you gotta change the bylaws, you gotta have multiple public hearings, you gotta take notes, you gotta warn it, just the timeline thing. So just to synchronize to be a time saver, which is resources, that's money, that's staff time, it's capacity.
Having served in that capacity, would it make any sense to have an annual one hearing where you review all the bylaw changes?
Sure, but that could be just as problematic, because I mean, it's already, people complain about how long it takes to get those things through. You have to queue it all for once a year,
So you see this as a major time saver.
not a pager, but a time saver.
A time saver.
Yeah, and I think generally when you pass the changes in the last few years, towns have tried to do that as a package so that they were limiting how many hearings they were having to have anyways, but I do think the issue comes up of, when you make a change to the statute, the municipality is required to comply with it. And so having people raise objections to it, the town still has to comply with the law. That does not mean that they shouldn't have the opportunity to raise objections to how it's being implemented at the town level. So I do think there is a balance to be struck here. Not all of these statutes are black and white at the town level.
That,
The LCT asking for and supporting this language.
I believe so, yes.
Are there groups out there that are maybe
No, I don't think so.
being
Just me.
cautious? Yeah.
Yes.
Okay. Understood.
Yes.
and our regional planners have weighed in supporting it.
I don't recall.
We got an email this morning.
Okay. Okay.
This doesn't prevent them from doing a public hearing, right?
Correct.
So
Correct.
I trust the select boards and the city councils out there to know that if this seems to warrant some of the traditional process, I trust that they do so.
Any other thoughts as we listen to this?
Oh, one more thought.
Yeah.
So similar to what we did with the rules, the bypassing or the rules for the labor department on synchronization. of
Right,
ownership,
this is similar, except state, local.
would a caveat be that any 25 persons could petition to have it go through the traditional public hearing process? Has that been considered?
It hasn't been considered. There was not a ton of time spent on this provision.
Oh, interesting.
Exploring to address your possible concern from unidentified stakeholders?
I'm just raising the issue. I'm also not saying that it is an issue. But there was not a ton of discussion, honestly, on this provision in the House, and so I did just want to flag it.
We can noodle it. So
Yeah.
this is we're hearing this for the first time, so this is something worth,
Very valid.
Thomas, we will look at that. Okay. BLCP and the planners weighed in this morning in an email to all of us, I believe.
So, the last provisions,
I don't think that was the planners though.
It's CCRB.
Oh,
Yeah, that was the RPC.
I meant,
I mean,
thank you.
no, there's VACTA. I mean, I don't think it, I'm looking around.
It's the regional planners.
Yeah, you just.
Sorry.
Or why
Not
are you-
APTA,
wrong.
but the regional planners.
so the last section, that I drafted is section 12, and it's what's in your bill currently, regarding the appeals study by the Land Use Review Board. It's the same language, so, it's moving up the deadline for the Land Use Review Board to submit their report on appeals to, November 15th, 2025, and then asking them what resources they would need if they are recommending appeals be heard by the board.
Right.
And that's the same as what's in your bill.
Thank you. And this is very clearly not Act 250. This is very clearly municipal appeals. And, right.
The study.
No, not the study.
Oh, the rest of the language is municipal appeals only.
Yeah, right. And, okay, so we certainly have something to consider, a way for people to petition if there is a bylaw that comes down that's gotten lots of notice and attention and people want actually to have a hearing about.
But I'm fine with it as is. If anything, if this gets into law, people have objections, we'll be here. There'll be people here again next year. Consider that.
Okay, great. Ellen, will you stick around while we, why don't you just stay right there while we have Kathy weigh in?
Okay.
Kathy, welcome.
Hello, everyone.
Hello, Kathy. It's good to have you. We miss
My
you.
apologies. I really wanted to be there in person, but
That's
couldn't make
okay.
it.
Yesterday in Windsor, I thought of you with all that developmental soil having had to be removed.
That's right. Yeah.
So you have asked to weigh in and then, and I know John has and Thomas, so we would love your input on municipal appeals and what these sections, how these sections do or don't satisfy some of the concerns you've had.
Yes, thanks so much. For the record, Kathy Byer from Evernorth, and Ellen, thank you so much for giving such an excellent walkthrough of the changes. I think most of you know that Evernorth builds affordable rental housing across the state for the last 35 years. And unfortunately, we've had several projects that have been appealed to both the environmental court and the Vermont Supreme Court. I, just from my own memory, wrote down the number of appeals that I could remember, and I could come up with 8, and I have a feeling that's probably not a comprehensive list. So as you can imagine, I'm very interested in the language regarding appeals of a local permit, and I will say, I think you've heard me say this before, the most frequent appeal we get is of the local permit. And with a very strong desire to see improvement, I would advise some caution today. And here's the reason why. So Ellen described that really what this language is doing is a trade-off and saying, you know, current statute is an interested person, but with the qualifier, that interested person must live in the immediate neighborhood. And that's being replaced by this concept of an aggrieved person standard, which I understand has perhaps more case law on what is an aggrieved person, but it removes the qualification around being in the immediate neighborhood. And I don't know, I don't know if that's the appropriate trade-off. You know, are we gaining? You know, I would, when I say gaining, I mean we're trying to perhaps not narrow, but say that someone who appeals needs to show impact, right? Through the aggrieved person standard. So, but it does make me nervous to give up this concept that they need to reside in the immediate neighborhood. And I did check in with 2 land use attorneys who I respect, and one of them strongly supported the change, and one of them did not.
There we are.
But they both commented on that really what we need in order to, what the real problem is the amount of time it takes an appeal to go through the process, right? And we've talked about that. And in fact, one of the attorneys pointed out to me that rather than, you know, if under either definition, a developer could, if somebody appealed, a developer could ask the court to determine whether they had met this definition of an aggrieved person or met the current definition of an interested party. And then you have to go through a court process to determine whether they actually have standing, and that the recommendation would be, don't even bother fighting standing, just get to the issue, get it in front of the court, because it just all takes too long. So that was some feedback from one of the attorneys.
So Kathy, on that, wouldn't the court look at that before they took it up? Wouldn't they look and see, is this person an interested person or an aggrieved person, make that decision about whether they were going to proceed with the hearing or not?
Again, I'm not an attorney, but I believe in order to do that, that means you are in the court process. You're adjudicating whether the person has met the definition.
So somebody has to appeal to.
So, okay, so let's say that they have this hearing to determine if they're aggrieved. I'd like to ask the courts if they have determined someone is not aggrieved, because this has been my concern all along. I don't know why they let people appeal and appeal and appeal. And 2, if someone loses that first appeal
Yeah.
How are they still considered? I think we are missing the links that overcomplicate this matter. I worry about the one aggrieved person versus more geographically proximate people. I wonder if we could do both. One or the other. I don't know about one aggrieved
do
person.
and-
I don't know what the
and-
definition is.
And you could do and or instead of or. Tom,
If I may, does this language attempt to get at the issue where somebody in an adjacent neighborhood who isn't really aggrieved can still have standing? So if anything, this just better synchronizes with other case law or court conditions where to have standing, you have to be aggrieved regardless of where you live. So isn't that an improvement? Because I can tell you from South Burlington's perspective, there are neighbors or people in neighborhood that aren't aggrieved, but still appeal because they just don't want housing in their backyard.
right.
So I'm kind of seeing the benefit of this
Right.
language, but I'm looking at Kathy to understand if my interpretation of this change is consistent with the intent.
Yeah, and that's why I want to say I don't know. And I just wonder, yeah, I mean, it's like it's a big step, right? And I'm just wondering, well, I hate to say, pause, but is this being we have the work of the land use review board, right? And as Senator Ram Hinsdale pointed out, that report's going to be due now in November. Would that allow more time for this discussion? Because this is exactly what I'm worried about. Are we better by taking this step, or
Should we leave the blurb to do it?
My understanding is correct. I think we'd be better off with this language.
I would say the reason that we hear two opposed perspectives from two different attorneys is the one who thinks that there's still a path is thinking like the attorneys who will exploit that path. I have dealt with every single loophole that people have found around the language we've had for the last 2 years. And I actually worry we're creating another loophole rather than removing one.
So then would you rather just let the blurb proceed and do their work and present their suggestions this fall?
I'm okay continuing the conversation with Chair Mahali and others. I mean, I agree it's helpful to have attorneys, but I wouldn't exchange one condition for another. I think that's a false choice.
So we
I would continue to narrow what it means to be aggrieved. And I wonder, I mean, I'm thinking of the Putney case. They had an abutter who just said, I'm next door and I don't want to see any housing built. Could we define aggrieved so that that doesn't count as being aggrieved? Because if not, I don't see how we're solving any problems. They could always find someone who's next to the project
right.
to front the appeal.
Thomas.
Where I'm hearing you is, I thought the benefit of this is that in right now reality, if a person is aggrieved, they can sue. They can prove that they're being aggrieved. And so this just synchronizes that. The concern that you're now validly raising, and I'd love to hear from the courts, is when people contest to have standing being aggrieved, is that the possible opportunity to further delay an appeal. I don't know how lengthy that process is. If you want to pursue being identified as aggrieved, is that a very lengthy, meticulous process that can be bludgeoned or used to stall projects? Is that your concern?
Attorneys would know better than I would, but we're removing other conditions like the number of people and the proximity to the project in exchange for one person who said they're aggrieved.
But
I don't know I don't know what it means to prove you're aggrieved.
That's what I like.
And if you have enough money and a good enough lawyer, I think you can prove that. And I worry, I just worry we have seen people.
That's where I welcome.
I really want to know what we mean by aggrieved, and I want to know what the court is going to do with that.
So were you here when Ellen went over what it means to be aggrieved at the moment? Because we could also add to that.
It's a definition in this section of law.
Yes.
Yeah, I mean, it doesn't, It's fleshed out in case law, but it's in section 8.
Did
Okay,
the
but-
house come up with this definition or it's?
Before we go to that, let's go back and review that, but Keisha, I'd like to go to the Putney case that you raised earlier.
Mhm.
The Putney case, the number of appeals, is there something if we do this and? Because I think there are some ands that we should be doing rather than ors, I agree with you. Is there something, instead of limiting the amount of time the court could take to resolve a case, could we not simply limit the number of appeals that can be done? Why haven't we done that?
If I could just, if I could just,
It's frivolous.
unfortunately, in Putney, first we were appealed on the local permit, which went through the environmental court and state Supreme Court. And then we also needed a jurisdictional opinion that we indeed met the definition of a priority housing project. And a jurisdictional opinion is also appealable. So it was the reason there were, it feels like several appeals, but it was 2 appeals of 2 separate permit decisions.
Okay, so,
Kathy, I have been trying to figure out if states like Massachusetts have been able to make progress allowing a project to continue when it's clear that the project will ultimately be built and the negotiation over mitigating harm is about shrubbery or aesthetics or something like that. And we could, in an effort to try and pilot this, just say a priority housing project or an affordable housing project, while it's being appealed, can continue to be built. I'm talking to the banks because I know they're critical in all of this, but I just think when a group like Evernorth or BHCB gets involved in a project, it becomes more obvious that they were going to do their part to be good neighbors, and they have the full faith and credit of state government in some way, and they should be allowed to continue developing their project. It should not halt all progress to be appealed.
Yeah, the hook there is our construction lender we wouldn't be able to close on the deal. We need a permit opinion from an attorney that says we have all permits in place and we've resolved all appeal periods.
And that's completely true in New Hampshire and Maine as well.
Yeah.
Like there's no.
Yeah.
And New Hampshire and Maine, it is easier to develop densely, is the sense that I'm getting. This is when we talked about the cost per unit, it all in my mind came down to the formula having a lower number of units per project here, which is often what happens after appeal, is there's a reduction in the number of units.
right.
That is
And
true.
can we stop that from being negotiable? I think it's a public good to have more units. And I wonder if we can just stop allowing people to use the courts to negotiate down the number of units.
I don't know how that fits into appeals at the moment. That's maybe a separate
Well,
section.
because people are getting extorted in this process to meet demands of other neighbors to create single family housing or much lower density. And I want to take away the power of this appeals process to have that kind of effect on projects.
So maybe you answered this, Kathy, but I maybe didn't hear it. So how many of your appeals are on number of units?
That's not usually the reason people give. It's traffic.
Yeah. Yeah.
It may be their goal, but their reason
Yeah.
is.
If only they'd come out and say, I just don't want to this make.
Look at that smile on Kathy's.
How can I smile? Right.
Right, exactly. So it's traffic's the number one reason your kids,
Other
Which
reasons are given,
masks-
but
which
yeah.
of course masks many other concerns.
Yeah.
But they'll grab on anything they can find in order to stall the process. That's why we're having this conversation. So they'll look at buffers, setbacks, trees, anything they can. There
Aesthetic.
many times, what the problem is exactly center on Hinsdale is people don't want that high density of housing near where
Right.
they currently live. Because
Right.
they're just worried about change.
I mean, I
But-
honestly think I'm sorry to interrupt.
Please.
I honestly think we have to make progress on the amount of time it takes to resolve an appeal for housing.
Right.
And housing gets thrown into all the universe of possible appeals, whether it's, sensitive ski area expansions or pick your, I actually think housing, and not just affordable housing, all housing needs to have a more expedited appeal process to resolve all the things we're talking about. The possibility of extortion, the reduction of units. If we can get through it more quickly and resolve it, we can not only get it built, but we don't have to negotiate on things like number of units
Right. So with that as your objective,
that's my objective.
I know that's your objective. So the question is, do these sections help at least begin that reduction? What would you do to change it? Might we sunset these for a year after the LURB sets its new things? I mean, if you're concerned about the overlap of what the LURB will come up with and what these may do, is it worth us considering sunsetting these after a certain period of time? I mean, so that we don't
Well, Kathy can answer that question, but I also hope, Kathy, you're looking at S-133 in natural resources, because that you can't often tell the courts what to do, but we can tell the executive branch to
Right.
do with the A&R permits more quickly.
Yeah.
And that's what that bill does. So, and then I know
Right.
we've talked about the Housing Board of Appeals, and I just want folks to remember that conversation ended last year because no one was talking about replacing an existing step along the way. It was an additional step, which would have cost money and had no guarantee of reducing the amount of time.
Right.
I'm willing to take that leap of faith one day, but not while we have so little money with the risk that it
not
actually
at the
will
moment.
help.
Right, not at the moment. So I guess we're at this point, at this moment, with this language, Kathy. What you are our most experienced developer in the room at the moment. What would you recommend? Well, I mean, other people are listening.
I'm actually advising caution. I'm not sure that you should move forward with this language from all the concerns that you've expressed today. And I don't see that it's getting at the real problem, which is the amount of time it takes to resolve an appeal of a housing development. We've just got to find a way to
Are there any
reduce.
timelines that could be set for particular pieces of process that will automatically come into play if those timelines aren't met?
I think Ellen mentioned that the courts aren't usually receptive to having timelines.
I know that.
But they may not be, but A&R may have to be. And
Correct.
if due process isn't able to be limited, I mean, sure, we can limit some of, I mean, one would assume we could set a frivolous bar. There already is a frivolous bar set, right? Yeah.
Maybe this is to Ellen, but to address these concerns, I mean, what if we left the adjacent neighborhood, those restrictions, but further qualify that they have to also, that subgroup needs to demonstrate that they have been aggrieved? Was that considered by the House? So if we take our current world of people that can appeal, I mean, narrow it even more, that you need to show that you are actually aggrieved.
Protected by section 8503.
Yeah, and that's the list of all the environmental statutes.
So
We
could
should
we
say-
remove some of the environmental statutes from what it means to be aggrieved?
No,
Not even like a sub definition,
I
notwithstanding
think-
here.
I think for municipal permits, you could potentially clarify, like, it is slightly unclear to me because the municipal permit chapter is very broad. What the specific interests within 117 being protected are, as opposed to like Act 250, it's the enumerated criteria.
Right.
With chapter 117, it isn't, zoning can cover everything.
Mm-hmm.
And so I do think there perhaps you could be more narrow.
Well, I would only be comfortable moving forward with this if we were more narrow in all cases. If we narrowed what aggrieved me into a definition that we feel comfortable with.
And so particularized interest from an injury from the permanent issue has been fleshed out by the court to mean a specific injury to that person, not suffered by the general public or a general
I remember
public.
that, yeah.
And so it has to be fact specific on what is happening on your property and your interest itself. So there is actually a lot of case law on people being denied.
So, okay, so you're saying if someone does drive by and say it's ugly, I don't want to look at it. But a neighbor can still say, I don't want to look at it.
Not under
Not under this.
not
Okay.
with this.
So I just want to run through, like, can they say the traffic will increase either way? If they're like in an adjacent street from Route 7, they can say the traffic will increase.
if they say they have
That's
to
why
make
they
sure
hide behind
that, like,
transportation. So
That their neighborhood would see an increase in traffic versus stuff.
and it would have to be more specific potentially. There's actually a lot of case law on how traffic is addressed in aggrieved person standard that I'm not told, like I was reading through it yesterday.
That is doing.
There are times when traffic can be
Mm-hmm.
an injury and also can't be an injury. And so I do think there have been distinctions between sometimes this person drives on this road. They're concerned. This is someone's everyday commute. Or how they are currently transporting their goods. Or, you know, their business operation. So there have been a lot of cases on that.
Thomas.
So, yeah, you were testifying on that, Bill, the other, when we were talking about traffic, but the particularized interest is really why I do see
Yeah.
what Representative Mulholland presented as this moving us in the right direction, because person agreed with the traffic example that precisely came up. You can't just say, I don't want more traffic in South
We have to
Burlington.
have a fix.
You have to say that this traffic will affect the berm or the road condition on the dirt road that I have to use every day on my land. So you have to be particular in your specific interest. So I do see this as still meritorious.
I think you just hear Kathy and myself saying, I want to believe you. And if I'm not sure, then I sure as heck don't want to do anything that could make things worse if I am not sure.
And that's why I welcome testimony.
We have to have that.
What it takes to
Yeah.
qualify in the court system as
Right.
being agreed, and if that can be weaponized.
And we probably should hear from attorneys who say, I think this is a step down. They would know better than most how it can be exploited to continue to lengthen appeal.
Well, I think on that point, let's welcome John. Would you like to pull your chair up and join Ellen? Just join Ellen.
On the point of people who know how to exploit loopholes.
No, but John, but it is it a
I'm not gonna copy on it.
Why don't you pull your chair?
Oh, well, I'll get the chair out.
Right.
Oh,
Come join us and share
Okay with it,
your input on these
Of
sections.
course you have,
Yep.
yes. Oh, boy.
John, have you met everybody here?
No, I don't believe
David?
we've met. I'm John Rodman. I'm the Policy and Water Program Director for, the Vermont Natural Resources Council. And, do you know BRC generally? I don't think it.
I'm aware of
Aware
I
of
haven't
it.
worked with.
Yeah, since Keisha knows she used to be on the board.
So did I.
You did?
As well.
God, I want
Over
to
60
go
years
on.
old, environmental advocacy group, the largest in-state group, got 4 programs, water program, climate and energy, forests, health, and sustainable communities that deals with things like Act 250 and land use and planning. I am also a lawyer. So just to give you the spiel on sort of like my perspective on this, and I agree that it's impossible. Like you'll hear different things from different attorneys. So I'm an attorney. I've been practicing land use law in Vermont since 1995. I was the general counsel for A&R. I was the Act 250 attorney for A&R for about 5 years. Before that, I was the chair of the NRB for several years, so I've administered Act 250, so that's how that works. I've been on, my development review board and planning commission for decades in my town, so I've seen these issues from a lot of different angles. So I do think that, I'm in the camp. I could explain. I've been involved with lots of appeals, where the person aggrieved issue has come up and it's been challenged. And so, Ellen, so the issue with defining aggrieved is that really that's based on, as the chair said, the Constitution and due process. Really, we did not create person aggrieved. We didn't create particularized interest. That comes from long-standing case law from the United States Supreme Court on who could appeal anything, as Ellen said. It's not just environmental permits. It started to be used first by the Water Resources Board in Vermont with appeals of A&R permits, and a bunch of just case law decisions that said we're going to use the person aggrieved, that you have to have a specific interest, as you were talking about. Act 250 back in the day actually had, much like zoning does now, it had different standards for appeals. It said if you could materially assist the district commission, you could appeal, right? So you didn't have, and states can, we talked about this a lot in the House, states can expand who can appeal, but they can't. The issue is you can't contract it to the point that you're taking away people's due process rights. So that's sort of
That's the
right.
That's the rock and hard place.
Yeah. So the Act 250 used to expand that by saying, hey, we're not even going to say you have to have an interest, you have to have an injury, you have to have a specific injury. We're going to say you could assist. You have expertise, and BNRC and other groups use that a lot because we have expertise. That was done away with in 2004 in the decision that was made when we eliminated the Natural Resources Board. We sent all the appeals to court. So before 2004, I think it's also important to note, and I think part of the problem with appeals and delays is we sent before 2004, and our permits went to the Water Resources Board. They went to something that was called the Waste Facility Panel. It was a waste issue. Zoning permits did go to court, went to Superior Court, and that was called the Environmental Court then. Act 250 permits went to the Environmental Board. So we had this split system, right? 2004, under Governor Douglas, said we're going to send all the appeals to the Environmental Court, and we're going to have a uniform standard for A&R, and Act 250 getting rid of materially assist. We're going to get rid of all the other language. We're just going to go to constitutional standing, person aggrieved, particularized interest. And we got rid of the other categories. For zoning, we left the zoning as it was. We said zoning appeals will still go to court, and we're going to leave interested person with any 10 people, immediate neighborhood, all the standards that are in the law now, except that we went from 10 to 20 people last year, right? So, I think we studied this a lot at BNRC for a long period of time. And one of the reasons I really think the ultimate answer, whatever you do this year, is this LURB study, where I think we all have to get together, the legal community, the business community, and the housing community, and other people interested in this, and figure out a better way to deal with appeals. Because I think that having all the appeals funneled to the court has clogged things up, slowed things down. The court is really process oriented, and that's what courts do. So that tends to strain things out. There's lots of motions that get filed. There's discovery back and forth, and that can slow things down. There was much less motion practice and discovery practice when we had the board process. And that's part of what we're going to talk about in the LURB study, is how do we have a more efficient system? How do we deal with things like housing that we want, and we want to move those things through faster? So a good example of the process is, so how is the process for person aggrieved? So I agree with Kathy that yes, the court needs to make a decision, but there's not like a mini trial. Every time BNRC appeals, probably a couple times a year, and really never zoning and never housing. I want to say that they're really A&R permits, sometimes an Act 250 permit, usually related to a very large commercial project or like a federal discharge permit or something like that. Our standing is challenged every single time. And so what we have to do is we have to prove that we have an interest, that we have members that have a specific interest. So we get affidavits that they have to sign. They have to explain their interest. We don't have a trial. All the papers get filed with the court. the court makes its decision. And we wouldn't take a case, we only take cases where we think there's an issue of statewide significance for policy. So we try to make sure that we have members that have those interests. But I have seen plenty of cases where citizen groups have appealed where they're appealing because they're upset about a specific project and they can't prove that they have a general concern about the issue.
You're saying they cannot prove.
They cannot.
They cannot.
And sometimes they can, and it's a mixed bag. It's not easy. It's something that when we go into it, we know we have to do that work. We got to go find members. They have to have legitimate interests. They have to be willing to sign affidavits, maybe appear in court if they have to. That doesn't usually happen. So I agree with Senator Chittenden. I do think that this is the constitutional standard. I think getting down to who is harmed is you have to show, and I can think of I'll give you one of the classic examples of where this came into play was the Bennington bypass from I don't know how many years ago. There was a gentleman who I think lived in the northern part of Vermont, and he read about the Bennington bypass project and he thought it was a terrible idea. And he thought it was going to create sprawl and stormwater, and he appealed the Act 250 permits and he appealed the A&R permits. And he got dismissed from the A&R permits because he was not a person agreed, because it was very clear that he didn't live anywhere near Bennington, that he wouldn't be affected by what was happening in Bennington. And so his appeal got thrown out. He was able to go forward with the Act 250 appeal at that time because we had the other standards. We had the weak or slippery standard. So that's one example. You can have lawyers come in here and
But he couldn't do that now.
couldn't do that now, right?
Right.
Yeah, under Act 250. I do think one thing that's frustrated with being in the court with determining person agreed. Usually it happens right up front, but not always. I think directing the court to deal with these preliminary issues up front, I would appreciate that. I had a case.
You mean, so that's, how does that not infringe on Zone A's concern about timing?
Well, so the court, I'll give you an example. So I was involved with the St. Albans Walmart Act 250 and zoning case.
We were too.
Back in the 2000s. And we appealed zoning permits and Act 250 permits and a stormwater permit for the Walmart. This is a long time ago, Senator Remens.
What?
So I know,
didn't
because
have
I remember
gray hair.
talking about some of these things when we
Right.
changed.
I didn't even have gray hair then. But
And it all resulted in the Rutland downtown.
I'm going to speak to an environmental problem solving class, funny enough, but I'd be okay with this language if we said 20 people with the same agreed who have
And
the same
not the immediate.
I would not support one person. I would support 20 people agreed with the same.
Okay, well, we're not
Agreed.
making a decision right now.
Okay, well,
That's
just
good
wanted to
know.
let you know.
so in that case, we had a trial, we had discovery, went on for months, cost a ton of money and time. And at the very end, after we had gotten through the whole trial, Walmart challenged our standing at the very end. And I lost my mind. I wrote to the court. I said, this needs to be done up front. We went through almost a year of trial. And now you're saying that we have to prove that we had the right to even be here. And the court said that, he accepted the motions, didn't throw them out, found we had standing. But I was shocked that could happen. And it hasn't happened to me since then, but ever since that happening, I was like, this is outrageous.
So have we not could we not then put in place that an appeal has to be done in X period of time?
Well, I think, that's a different issue. And the court, and, I get with the court, no one likes to be tied to those sort of deadlines, and you should talk to Judge Zone about that.
Right.
But I'm saying you could direct the court to address first.
That's what
Person agrees before you go forward with anything else.
was my question.
Yeah.
We have that.
Because it's not in the
Okay,
law.
so it's not,
Yeah.
it's just addressing the agreed person first.
Right.
But what if the agreed person shows up at the end as you?
No, you can't.
Yeah.
That's the thing. Because the deadlines, what we do have in the court process is that, so the appeal has to be done within 30 days of the decision. And then once the appeal is filed under the court rules, you have 20 days to enter an appearance. So that takes care of that. Then once you do that, then people could challenge your person agreed status. And then once that happens, it doesn't say that a decision has to be made. Although usually like now that is what happens, but having had that experience in Walmart, I would not want anyone to go through that again.
Tom,
This makes a lot of sense. I like the idea of, and I'm wondering if we have the capability of doing that and structuring the
Right.
process with the courts. But here's my next question for
Right.
you. Say we do that, if a party status needs to be established prior to some action that usually occurs with this, what does that ultimately, if one of the persons challenges the standing of another person, and that person doesn't have a lot of resources, doesn't have deep pockets, and they just don't file the paperwork, does that in the court just default to them not having standing?
Oh yeah, you will
Okay.
not win.
And I think we should have this
You will
be
not win.
required to have standing established prior to the next steps of the court process, from my naive understanding. of
You
how
have
this
to step up. You have to be able to present
Right.
evidence of your specific harm.
right,
So
so keep the aggrieved person as we have it at the moment. And ask that the court, that's not infringing on the court.
I don't think so. Although, I mean, you should ask Judge Zone.
Prioritizing.
I
People have judgment.
I think it's a procedural, it's the order of things. It's not, it has to get decided one way or the other.
Question,
Yeah, Randy,
is it conceivable that a decision in the environmental court, particularly if it's a middle of the road decision, that moves something slightly, if you will, so that both parties are satisfied and the court okays it, could create a new aggrieved party who was not in the original litigation to begin with?
You have, because of you have to intervene, you have to appear at the beginning. Otherwise you're out.
But what I'm saying is though, could a decision be reached in one way, shape or form that creates
you agree.
No,
an issue
No, not
that
in
did
that
not
case.
exist as
not
part
in
of
that case for controversy. I have a case right now actually involving aquatic nuisance permit in Lake Bomazene, where some citizens of well, actually the A&R denied the permit, and then a person appealed that permit to environmental court, and then citizens in DNRC who had commented on the permit, we intervened in the appeal, and the person who appealed was not the applicant, right? So we had this whole procedural debate. We didn't have standing. We had this whole esoteric debate about how could you appeal? You didn't even apply. While we're having that debate, and the real applicants try to come in to the proceeding and say, hey, here we are. Like we see this is going on. There was some preliminary decisions that were issued that they thought like, oh, okay, this implicates us. Maybe we do want to participate. And the court ruled, no, you're too late. You can't, you missed the deadline. You didn't appeal. You didn't enter an appearance. So you just can't do that. You lose your opportunity. Now the person appealed to the Supreme Court. So we're in the Supreme Court arguing the same thing. But anyway, so no, I don't think that can happen because you're within that case of controversy, you have to meet those strict deadlines, and that is fair. And that is very fair.
so is your counsel for us to wait for the LURB process to be fully vetted and explored, or is it, and take some of these concerns that are voiced in sections 8 through 11?
Well, we certainly supported the change in the House bill because it's the constitutional law. You know,
I mean, it already allows for a aggrieved person.
well, but it didn't spell it out. Like you could go beyond that. My concern about Senator Rem Hinsel's proposal is like that could be saying it's more than,
Right.
20 people, however, really, what about the one person who
Right.
is legit?
It's-
And there is another side to this coin. This is what's so hard about this issue is that like there are, like the Putney case is a terrible example.
Of one person.
Right, but there are legitimate cases, and so that is why the courts, the filter. I mean, this isn't a great analogy, but look at the terrible, what's happening with the courts trying to wrestle with due process, for some of the criminal, from some of the deportations now, and it's the same thing. Who has due process, and what is the minimal amount of ability that you have to basically have a hearing and have your say?
So what we're setting in these
It
sections,
is legitimate,
who has the right to due process
right?
under?
Right, so I think what the House did is they went, the House went to the floor of that,
in terms of.
As we
appeal.
did in 2004, when we said with Act 250, we're going to go to particularized interest in person and create. We're going to make it the flat standard. We didn't change zoning. And I've always been curious about any 10 people, or now it's 20 to sign a piece of paper. Like, yes, legally you could do that. You're expanding who has access to process. But I didn't think that was ever necessary. Immediate neighborhood, I think what the House talked about with that is you'd be covered by if you have a real injury. Like, it's just, so it shouldn't be enough that you just live in the immediate neighborhood, whatever that means. It's
No, you
not,
have to have
know.
a real injury.
Right,
I think.
right.
So what I'm hearing you say is you're supportive of these sections and obviously the LURB work going forward.
Right, but I don't think this solves the problem. I do think it's so tricky. I really
It
think,
doesn't solve the expediting.
well, and yeah, I think we need to have the discussion about how to, especially with housing appeals. I personally like the Housing Board of Appeals idea. I think that's, we heard a lot of testimony from New Hampshire. Like, if you have an entity that's just focused, right? And it's gonna give people their due process, but get the decision quickly. You could talk to Joe Zoni, then say that goes to the Supreme Court, that gets expedited,
I don't think
That
we
is
disagree with you
possible,
on that. I don't think this is the year for
No,
that.
no, no.
LURB,
I
if
think
the LURB
I think we
if the
need the
LURB
Lord
appeals
study,
board
yeah.
proposes that and then comes forward with a way we could
I
pay
agree.
for it.
I
I think
totally
we should
agree.
consider it.
And I
because-
would in terms of the cost, we're going to be participating in the LURB study. I think we have created a LURB. The LURB this year, as you know well, and you took testimony, they're very busy with their studies about a variety of things related to Act 250, reviewing the tier 1 plans that are coming through.
Yeah.
That work is gonna be over. It's consuming them, but then they're gonna have, we're paying 5 full-time people to be there. We could maybe use them, to focus on housing appeals or something, So I don't know. Those are some of my thoughts about
You mean they have
opportunities.
appeals go
Yeah,
to them first?
yeah.
Isn't that how it was hopefully envisioned at some point?
Well, we don't know. I mean, that's
That's
not
what
what
I'm
the law,
hoping
that's not what the
for.
law says, but.
Thomas, you had a
I
question.
just want to invoke something that Mark Mulholly presented right when he came in. The first thing he said was, this is not solving the appeals problem. It's just the right first
Right.
step in the right direction. And I see that, because if anything, this just makes it clear that to be an appellant, you have to have demonstrable aggrieved, you have to be aggrieved. All right, now our current language allows for non-aggrieved individuals to appeal anything that they want, to drag projects out and delay them and to negotiate with fewer density. So I do see merit in this language for all the reasons articulated by Mr. Groveman.
But Kathy, I'd love to reduce your worry. But I also know that we're at 10 of 12, and I know Thomas Weiss would like to weigh in a bit. Thomas, are you
Yeah, I'm
ready
like-
to weigh in on this conversation? You don't need to move necessarily. Would you like to weigh in on this?
I would like to weigh in before clearing chairs. I'll move. Thank you.
So I'm big into our being able to discuss it, together. So
Uh-huh.
happily, Ellen and John are not leaving, and Kathy. Thank you, Kathy, for staying.
Anyway,
Welcome. Do you know all of us?
I remember you from last year and I recognized the picture because I was trying to figure out who everybody is in this room before I came here. So.
Right. Welcome. It's good to have you.
Thank you.
Introduce yourself and
Right.
tell us your concerns of these sections.
Good morning. I am Thomas Weiss. I'm a civil engineer with a lot of experience in reading, interpreting, and implementing the contract rules and regulations. My testimony will be focusing on a lot on the actual words that are in 4 sections, sections 8 through 11.
This is your story. Okay.
Yes, this is my testimony. I did
Oh,
send
yes.
it in earlier.
Thank you
to
for
Heidi.
submitting it earlier. We appreciate
And
it.
she did just said she was going to do a bit on that.
And she did.
She followed through.
Heidi is.
Yeah, I didn't doubt it. And I'm going to skim through this a little bit. I'm going to start with the 2 sections relating to the chapter on environmental appeals. That's section 8 and the first part of section 9. As you're aware, it proposes to expand the definition of a person aggrieved. But my concern is that chapter 117, which is the municipal and regional planning and development chapter only uses the word aggrieved once. And that has to do with, the enhanced energy plans, mostly and it doesn't, so I'm not sure that there's a good fit in chapter 117 if aggrieved is put into the chapter, I think it's 220, which is the consolidated environmental appeals. So it doesn't seem to me to have a benefit because using aggrieved in the appeals chapter isn't a good match with how the planning and zoning chapter is, planning and development chapter is set up. So my thoughts are always to, well, if it's not making sense, not having a benefit, then to take it out.
Where would you put it?
In
If
terms,
it doesn't fit in 117, where would you?
well, to me, it would require a reworking of chapter 117 to bring the concept of aggrieved in context of this bill into the chapter. And that would probably be a lot of work.
Do you want to respond?
Yeah.
Sure. So I kind of alluded, I don't agree with him exactly, but I kind of alluded to the fact that Act 250 has enumerated criteria,
Right.
and those are the interests you look at to be protected. Chapter 117 doesn't have an enumerated list like that, and zoning covers most things. It has the list of interests in 4302 of what the goals are for what the intent is to protect as part of zoning. And so I do think it is broad. And so when Senator Rob Hinsdale asked about that, I think perhaps you could specify what are the interests you're trying to protect. I do think while using person aggrieved is something you could do, it is not exactly the same as the way Act 250 works. So there would, if you don't specify, the court would be looking to try to decide that when it first starts hearing cases of this.
Sort of like identifying our intent on things. If
Yeah.
So we need to, if we're going to do this more narrow definition, that it would benefit us to specify the interests that we're trying to, what we're trying to prevent and protect.
Yeah, and so just to clarify, it's not tied to the word aggrieved within the statute. It's what are the chapters, what are the interests that the chapter itself is protecting? And in chapter 117, it's a little bit more vague than in under Act 250.
Okay. Sorry.
Not a problem.
No, it's very helpful.
The second part of section 9 proposes to require the environmental division to determine whether applications for a permit are consistent with the bylaws. Often permits are approved with conditions that are required to make the project consistent with the requirements of the bylaws or land use. And the conditions remove the project's inconsistencies. So the way I read the second part is the court will not be reviewing whether the project is consistent with the bylaws or the permit is consistent with the bylaws, or only whether the application is consistent with the bylaws. And I have no idea what it means for an application to be consistent with the bylaws. Under Act 250 and other ones, there are determinations as to whether the application is complete. So I would think that that is what would mean to have the application be compliant with the permit process or the bylaws. So, and if you were to correct or alter the word applications, go back to projects and permits, then there's no need for that part of the section at all. Because that's, I hope that's what the court is already doing.
Okay, is everyone following him?
I want her to follow this.
I know, because I'm not.
I mean, that's the parsing of words that I've had to do especially during construction supervision or construction
Right.
monitoring, with contracts. It's really, what do the words actually say? And
Right, and so we're really concerned here with the project, not with the application, whether it's complete or not. That's really a determination of an
that's my point
application.
on this one.
Okay. Yeah, okay,
The third part of section 9, you've already heard about that, is that it doesn't really put any requirement on, that's the requesting the court to prioritize housing with the loophole exception.
right,
And so with loophole exception, we heard Ellen talk a bit about how it doesn't change things a whole lot. So, why bother to put it in?
right.
Section 10 proposes to remove 2 classes of interested persons from those of the able to make appeals, which you've heard about. The chapter 117 uses interested person in 6 locations. The very first of them, 4301, doesn't apply to this process at all because it has to do with land use. Planning and land use manual prepared by Commissioner of Housing and Development. So I would suggest changing B in that section to have it only apply to subchapters 10 and 11. Because those are the other places where interested persons are used in chapter 117. So it's clear. I don't see how it would apply to the others, but we've got that one other outlier of it. So that's the suggestion. In terms of skipping around here, because I know it's getting
Skipping to section 11?
Well, no, I'm down to section
Bottom of page
section
2,
10, bottom of page, 2. Well, I'm not sure where it is because I've got a couple of page copies so I can mark it up and cross things out.
the removal of the 20 voters.
No, this is the proposes to remove persons owning or occupying property in the immediate neighborhood. I guess I've always been under the understanding that relates to the particularized interest that you're talking about. Without actually saying it. And my overall concern is that over the years, the ability of standing to appeal have been reduced. Reducing public hearings, reducing the ability of voters to approve or deny laws. And so I'm concerned about reducing the ability of the public to weigh in on issues.
So that's your overall concern here, is that it's reducing the ability for the public to weigh in?
Well, that's the third type of interested person. The fourth type.
So hold on 1 second, Thomas has a question.
So my concern, and I really appreciate your testimony, that the Vermont National Golf Course on Dorset Street, there are neighborhoods near there. There was a proposed development for 90 units on a few acres. And the neighbors over there, who I don't think had any particularized interest, they just didn't want a bunch of houses where there's currently a field. Do you think they should be considered to be able to appeal and have standing just because they have a neighborhood that is kitty corner to a potential development?
I think in this process, that is the responsibility of the viewport. Is that what South Burlington has?
So it got dragged out to the point where now that, and then the laws
But-
changed and the houses never got built.
But what I'm thinking is that the responsibility for determining whether somebody is a type 3 interested person resides with the appropriate municipal panel, zoning board of adjustment, the development review board, and the planning committee. And it's their responsibility to determine standing first. So if they determine that the person does not have standing,
That's what we're talking about here right now. The current language gives them standing because they're in a neighborhood that somewhat is close to where this
Right.
land is. What we're talking about is they instead would need to show that they are being aggrieved by this potential development. Am I wrong?
that's part of what the Development Review Board would go through and determining whether they are an interested party and are allowed to participate as an interested party in the hearings.
That's just why I see this language as an improvement, because just being in that neighborhood, I
It's
don't
not
think they're
enough.
agreed. I don't think they're agreed.
Yeah,
And if my interpretation of what that statute has meant is wrong, then
right,
I have to stand corrected.
right. So Thomas, tell, and you have another couple minutes.
Right, I know it's getting into.
I know, we're coming right up against it, so,
Section 10, that's the fourth type of interested person, the ability of any 20 voters, residents, or property owners from holding the appropriate unit of that accountable. That's definition actually goes back to the creation of this language in 1968. If I go back before that, I haven't been able to track it down, but it talks about relief. And to me, relief is something that a variance does. The Development Review Board relieves the applicant from having to follow some of the requirements of the bylaw. And so I looked up the definition of relief, because it doesn't appear to be defined in relevant statutes. And the way I read it is the class 4 is really intended to allow appeals by a small group of concerned individuals when, for example, the Development Review Board has allowed a permit that does not require the project to comply with the zoning bylaw, or when the Planning Commission has created a bylaw that does not comply with the town plan. And so my concern is that by taking out this type 4, that type of appeal has been removed. It's possible to tighten up the language to make sure that it applies to decisions where the board planning commission zoning board of adjustment aren't actually doing what they're supposed to be doing, or there's a claim that they're not actually doing what they're supposed to be doing.
Last question, if I may.
yeah, yeah.
Did you present these concerns to the House? Have you already?
Well, that was, couldn't be my question.
I sent them a letter. I did not testify. My problem as an individual is that it is very difficult for me to keep up with a committee bill, because by the time I figure out what comments I want to make on one draft, there are already 1 or 2 drafts beyond that.
It's hard for me to.
So I did send them a letter with some of these comments, but I did not request to testify.
That's what you requested it with us, so you're
Yes,
here.
I did.
So can you finish up, because we
I
all
can
said we have
finish
to
up
get going.
quickly. Section 11 proposes, and you heard a little bit about that. The way I read section 11 is it allows a municipality to prevent public hearings on any zoning bylaw amendment going on into the future. Because it's a wording issue, because they will have to well, if it has to do with in residential areas, you have to allow a certain number of housing density. You know, you have to comply with that. But as Ellen mentioned, the boundaries of district
Right, this
can
may
be
be,
adjusted, and so how does the public weigh in on?
so your feeling is sort of aligned with Ellen's, that maybe even though it might reduce hearings for our local boards, that it may be a step too far.
I definitely think it's a step too far.
Yeah.
My recommendation is to remove it.
Yes,
I have heard the suggestion of perhaps allowing a number of people to petition for and force a hearing.
yes, that's Thomas's suggestion.
I wouldn't go as far as to suggest, just seems like a notion that we gravitate.
That we might want to talk about.
Right.
It's not-
I
not
think that
we-
that's a potential, if you're trying to reduce that. I
Right.
mean, Montpelier's going
I think
through
that-
its,
I think we're trying to have our cake and eat it too.
Yeah, I mean, Montpelier's trying to go get through its town plan revision, and they've been working on it 7 or 8 or 9 years through, 3 chairs planning commission and that sort of thing. But so I'm not sure eliminating all hearings is not appropriate.
Right,
And I don't necessarily have the same trust that you do, that the select board or the city council
or the planning
are
commission or whatever.
going to decide on whether to hold public hearings in the way that I would like them to decide.
Right, so thank you very much. We need
You're
to
very
end it
welcome.
here.
I know.
We're
And
We're really grateful. No, we've
thank you for
gone
giving
6
me a
minutes.
few extra minutes.
We,
doesn't
and we appreciate your thoughtful memo. This is terrific. And we'll get Ellen a copy too, so that she can see it. And, thank you, because we will weigh it all and stay tuned.